Hi, everybody. Today we're going to be talking about President Biden's new announcement with regards to an executive order to keep families together. On June the 16th of 2000, I'm sorry, June 18th of 2024, President Biden made a great announcement, and everybody in the immigration community, immigration lawyers, immigrants, were very excited, and we've been getting a lot of calls and emails asking for clarification and just what the requirements are. So today we're going to be talking about those requirements. And so what does it mean right now, as of today, which is June, end of June? There hasn't been any forms on USCIS.gov to process these applications. This has not been entered into as an executive order as of today, the filming of this video. If anything changes, I will definitely come back and do another video. But as of today, which is the 27th of June, there has not been anything substantive to say this is how the process would go and this is how it will be filed. What we know as of today is what the requirements are, and those are the things we're going to talk about today. So the requirements to be considered for this is that the petitioner has to be a U.S. citizen. So you have to have a spouse who's a U.S. citizen. Unfortunately, if you do not have a spouse who's a U.S. citizen, you cannot qualify for this. And it is geared towards people who came in, crossed the border, and came in illegally. If you have a visa and you're married to a U.S. citizen, obviously you can change status. You can adjust status in the U.S. because you came in legally. So this law, I don't really think benefits people who came in legally on a visa. This law specifically benefits people who are married to U.S. citizens, are able to file an I-130, but are concerned about leaving the country to the U.S. embassy in the country where they live, where they're from, or where they're citizens of, to go get a green card to come into the U.S. So I hope that kind of clarifies the difference between those who can benefit from this process and who cannot. So again, let's talk about requirements. One, this is a discretionary grant of parole. I'll say that again. This is a discretionary grant of parole. It is going to be on a case-by-case basis, which means that you have to show that you are eligible. You have to show why you are eligible. You have to file an application with USCIS, and then USCIS will make a decision on a case-by-case basis. Two, you have to be physically present in the United States without admission or parole. We talked about that. You came in illegally, you crossed the border, you EWID, which means you entered without inspection. You would benefit from this. You have continuously been present in the United States for at least 10 years as of June 17th of 2024. So if you have not lived in the United States physically continuously for a period of 10 years, unfortunately, you would not be qualified for this relief. And then, most importantly, you must be married to a U.S. citizen. It doesn't matter if you're married to a man or a woman. It doesn't matter. It's just that you have to have valid documentation showing that you're married to a U.S. citizen as of June the 17th of 2024. Individuals must not have disqualifying criminal history. So there's nothing, you don't have any convictions that preclude you from being able to get admission to the U.S., which means you don't have a crime involving moral turpitude. You don't have an aggravated felony. You're not a threat to national security or public safety. And your children who are non-U.S. citizens can also be paroled in under this process. Again, as of today, the filming of this video, we do not have concrete forms or how much the fees are. But as things unfold and as we're able to get more information about this beautiful, very beneficial parole process that has been announced by the White House, the President Biden's White House, we will continue to give you more information. And thank you. I'll see you on the next video. Bye-bye.